Okay, let's unpack this. Cast your mind back. Remember being, maybe 16 or 17
Oh, yeah.
and wanting to buy something significant, something that felt like a proper adult purchase.
Definitely. Maybe a first car or something like that.
Exactly. Or a fancy phone, or signing up for some kind of training or membership. You felt ready, ready to sign on the dotted line.
Absolutely. Felt like you knew what you were doing.
But legally speaking, could you? Was that piece of paper, that agreement, actually binding on you?
That's the core question, isn't it?
Welcome to the deep dive. Today, we're plunging headfirst into a really interesting corner of contract law. We're focusing specifically on agreements made by young people, by minors.
And it's a fascinating area, like you said, because it constantly tries to balance two things.
Right. On one hand, the law wants to protect young people who might be, well, inexperienced or easily influenced.
But on the other hand, there needs to be some fairness, some certainty for the adults or businesses who are making these contracts with them. It's a real tightrope walk.
It really is. Now, this deep dive is based on educational materials generously made available by the University of London, and these are intended purely for educational purposes only.
And we're really grateful to have access to this kind of detailed material to guide our discussion.
Absolutely. And this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
Okay.
Now, we know many of you listening are probably tackling this exact topic in your studies. Maybe you've got an exam coming up.
Quite likely it's a core topic in contract law.
So our mission here is to take this comprehensive source material, pull out the absolute key rules, the concepts, the important cases, and unpack them in a way that, well, makes sense and helps those crucial points stick.
Yeah, so you feel confident applying it.
Exactly. We want you to feel ready. So to all of you studying this, hang in there, keep working at it, and genuinely, good luck for the exam.
Yes, best of luck. And this area of law, despite that tension we mentioned, it does have a very clear structure. Once you get your head around that structure, applying it becomes much more straightforward.
Good, so we'll follow that structure.
We will, directly from the source material. We'll start by defining who the law actually considers a minor. Then we'll lay out the general rule about their capacity to make contracts.
Oh.
But as you'll see pretty quickly, the general rule itself is maybe less important than the exceptions to it.
Ah, right. That's where the action is.
Exactly. So we'll spend a good chunk of time unpacking those really crucial exceptions, contracts for necessaries, and then beneficial contracts of service.
Got it. Necessaries and beneficial service.
Then we'll look at a slightly different category called voidable contracts, another key concept. And finally, we'll tackle the practical question of recovery of property. What happens if the contract isn't fully binding?
Right. Can the other party get their stuff back?
Precisely. The aim is to cover all the key points from the source material really thoroughly to give you that complete picture you need, especially for exam preparation.
Perfect. Okay, let's start right at the beginning then. Setting the stage. Who actually is a minor in the eyes of English contract law?
Well, the source material gives us a very clear definition, and thankfully today it's quite simple. A minor is a young person under the age of 18 years.
Under 18. Nice and clear. Wasn't always 18 though, was it?
No, the age of majority has changed historically, but 18 is the line now.
And what's the thinking behind this? The underlying principle? Why treat under 18s differently?
The fundamental reason, the why behind all these rules, is the idea that people under 18 are generally not seen as having the same level of contractual capacity as, say, an adult with full mental capacity.
Because they lack experience.
That's a big part of it. Lack of experience, potential naivety, and also a higher risk of what the law calls improvidence.
Improvidence, meaning
Meaning not fully considering the future consequences of their actions, especially financial ones. They might agree to something that seems okay now, but turns out to be really detrimental down the line.
okay, so the law steps in to protect them from potentially unfair deals they don't fully grasp.
Exactly. It's a shield.
Now, the force briefly mentions that minors aren't the only group with limited capacity, right?
That's correct. The source lists others, like individuals who are drunk or mentally disordered. There are also entities like unincorporated associations, corporations, even aspects of the crown or public authorities. They all have different sorts of capacity limitations based on different legal rules.
But for our purposes today, and for the syllabus, the source material covers.
It's only minors we're concerned with. The focus is solely on the contractual capacity of those under 18.
Just minors. Got it. And the law in this area hasn't just stayed the same over the years, has it? The source mentions developments.
Absolutely not. It's evolved. There have been significant legal changes, probably the most important one recently being the Minors Contracts Act, 1987.
Right, the 1987 Act. What did that do?
Well, it brought in some really important changes. It swept away some older, sometimes quite confusing statutory rules, particularly from the Infants Relief Act, 1874, and it introduced some new remedies, which we'll definitely get into later.
Okay, so bearing that development in mind, what's the basic starting point? The general rule about minors and contracts.
The broad general rule, before we get into all the important exceptions and nuances, is stated very clearly. A minor is not bound by a contract they enter into during their minority.
Not bound. Simple as that, as a starting point.
As a starting point, yes. And the core purpose behind that, as you identified earlier, is protection. Protecting the minor from their own potential improvidence or lack of experience.
But you also mentioned that tension.
Exactly. Because while protecting the minor is the main goal, the source material strongly emphasizes that there are situations where, fairness and justice towards the other party, the adults or the business, has to come into play.
Makes sense. You can't just let the adult party lose out completely every single time.
Right. Think about it. If a 17-year-old orders and receives, say, essential goods or services, uses them, should the supplier just get nothing back simply because the person was under 18? The law has to find a balance.
So that tension between protection and fairness is what drives the exceptions.
Precisely. Because the general rule says the minor is not bound, the really critical parts to understand, especially for exams or practical advice, are those situations where a minor is bound or where the other party has some legal recourse, even if the minor isn't strictly bound by the original contract.
And that leads us straight into those exceptions.
It does, the crucial exceptions.
Okay, let's dive into exception number 1. This is covered in section 7.1 of the source material, and it's about contracts for necessaries.
Right. This is probably the oldest and most fundamental exception to the general rule, and the rule itself sounds simple. Contracts for necessaries are binding on a minor.
Okay, binding for necessaries. But the key must be defining necessaries.
Absolutely critical, because the legal definition is much narrower and more specific than how we might use the word necessities in everyday conversation.
So what is the legal definition?
Well, for goods, it's actually set out in an Act of Parliament, Section 3, Subsection 3, of the Sale of Goods Act, 1979. It defines necessaries as goods suitable to the condition and life of the minor, and to his actual requirements at the time of the sale and delivery.
Okay, let's break that down. Suitable to the condition in life of the minor. What does that involve?
That means you have to look at the minor's specific circumstances, their social standing, their background, maybe their family's wealth, their general station in life. What's necessary for the child of a millionaire might be very different from what's necessary for someone from a less wealthy background.
Right, context matters. And the second part? And to his actual requirements at the time of the sale and delivery.
This is just as important. It means you have to consider what that specific minor actually needed at that precise moment the contract was made and the goods delivered. It's not about what might be generally useful or what they might need next week. It's about their specific situation right then.
So if they already have enough of something, buying more probably isn't unnecessary.
Exactly. That's a key point, which is why the source stresses that necessaries doesn't just mean necessities. A luxury item could theoretically be a necessary for a very wealthy minor if it fits their condition in life and they don't already have one. Conversely, a very basic item like plain clothes might not be a necessary if the minor already has a wardrobe full of perfectly adequate clothing.
That's quite subjective then.
It is very subjective, yes. And the source gives us some classic older cases that really illustrate this. Even if the examples seem a bit quaint today, the principle is vital. The key case establishing the importance of looking at the minor's specific status and requirements is Peters v. Fleming back in 1840.
Peters v. Fleming, 1840. What happened there?
It involved a minor who was the son of a member of parliament, so clearly someone with a certain social standing, a high condition in life. He contracted to buy some quite expensive items, including rings, pins, even a watch chain. The court held he was liable because these items were considered suitable for someone of his status.
Interesting. So his background made luxury items potentially necessary.
In that context, yes. It highlights how condition in life is a major factor. Let's look at another example from the source. Hans v. Slaney, 1800.
Hans v. Slaney, 1800.
Here, the question was about a servant's uniform, specifically livery, purchased by a gentleman minor. Was that a necessary?
You'd think maybe not for him personally.
But the court said yes, it was unnecessary,
Mm.
because employing servants and providing their uniforms was considered suitable to his condition in life as a gentleman back then. It was a reasonable expense given his status.
Well, okay. Very context dependent.
Extremely. Now let's contrast that sharply with probably the most famous case in this area, Nash v. Inman, 1908.
Ah, yes. Nash v. Inman, 1908. The waistcoats case.
That's the one. This involved a minor who was an undergraduate student at Cambridge University. So again, his condition in life was that of a well-to-do student. He ordered 11, believe it or not, 11 fancy waistcoats from a Savile Row tailor.
11. Sounds excessive.
The court thought so too. They held these waistcoats were not necessaries. But crucially, it wasn't because waistcoats themselves can never be necessary clothing.
Why then?
Because evidence showed he already owned a sufficient supply of suitable waistcoats. This case really drives home the second part of the definition, his actual requirements at the time. Since he already had enough, these extra fancy ones were deemed a luxury, not a necessary, even for a Cambridge student.
That makes sense. So, Nash v. Inman is key for the actual requirements element.
Absolutely. You need both parts.
Yeah.
Suitable to condition in life and needed at the time.
But thinking practically, like the source's activity 7.1 hints at, how on earth is the supplier, the tailor, or shopkeeper supposed to know all this? How do they know the miner's exact condition in life, or how many waistcoats they already own?
That's the million-dollar question, isn't it? And the short answer is it's very difficult. The law, in its aim to protect the miner, effectively places the burden of proof, the risk, on the adult supplier.
So the supplier has to make inquiries.
Ideally, yes, or at least be prepared to show the court that the goods did meet the definition for that specific miner at that specific time. It's a real warning that contracting with minors for anything beyond obvious necessaries is inherently risky for the adult party.
Okay. Now, say something is deemed a necessary. What's the consequence for the miner in terms of payment? Do they have to pay the price they agreed?
Not necessarily, and this is another crucial protective measure. If a contract is binding because it involves necessaries, the minor isn't liable to pay the agreed contract price. Instead, the law says they're only liable to pay a reasonable price for the goods or services.
A reasonable price, not the contract price.
Correct. So if the supplier tried to overcharge the minor, even for necessaries, the court would only enforce payment of a fair, reasonable amount. It stops exploitation, remember that. Necessaries mean binding, but only for a reasonable price.
Good point. And the source is clear that necessaries isn't just about goods, right? Services can be necessaries too.
Definitely. Things like necessary medical treatment, essential lodging, or even certain types of education or training could qualify as necessary services, depending on the minor's circumstances.
Okay. This brings up another point.
Mhm.
What about contracts where things haven't happened yet? Executory contracts.
Yes, where obligations are still to be performed on one or both sides. The source brings in the case of Roberts v. Gray, 1913 here.
Roberts v. Gray, 1913. Tell us about that one.
This involved a minor, Gray, who was an aspiring professional billiards player. He made a contract with Roberts, a famous adult professional, to go on a joint tour. The idea was Gray would play alongside Roberts, learn from him, essentially get training to become a pro himself.
Sounds like a form of education or training.
Exactly. The court considered this contract for training and experience to be beneficial, and therefore a contract for specifically necessary services related to his chosen profession. Now, the key thing is, Gray changed his mind before the tour started. He repudiated the contract.
So it was executory. Nothing had actually happened yet.
Correct. But the court held him liable for damages for breach of contract. So, Roberts v. Gray established that a minor can be liable on an executory contract, at least for necessary services like instruction or training.
Okay, Roberts v. Gray, executory contract for necessary services, minor can be liable.
Got it.
Now, the source poses an interesting question in Activity 7.2. It asks if the decision in Roberts v. Gray would also apply to an executory contract for necessary goods.
Ah, that's a classic point of discussion.
So if a minor orders necessary food for the week but cancels before the supermarket delivers, are they liable?
Well, Roberts v. Gray was specifically about services. Historically, the common law was sometimes a bit more hesitant to hold minors liable on purely executory contracts for goods where they hadn't actually received the property or benefit yet. While you could certainly argue the principle should extend, the legal position for executory goods contracts isn't quite as firmly settled by precedent as it is for necessary services following Roberts v. Gray.
So a bit of a gray area for executory goods.
A slight nuance, yes. It's one of those points where you need to be precise about whether it's goods or services and whether the contract is executed or executory. It shows the detail needed.
Okay, so let's summarize this first big exception, necessaries. Contracts for necessaries are binding on a minor.
Right.
Necessaries can be goods or services. For goods, the test is Section 3.3 Sale of Goods Act, suitable to condition in life A&D actual requirements at the time. Key cases, Peters v. Fleming for condition in life, Nash v. Inman for actual requirements.
Good.
If it's a necessary, the minor only has to pay a reasonable price, not the contract price.
Crucial point.
And executory contracts for necessary services can be binding, as shown in Roberts v. Gray, 1913. The position for executory necessary goods is maybe less certain.
An excellent summary. You've nailed the key points for necessaries.
Right. Let's move to the second major exception then. Section 7.2 in the source material. Beneficial contracts of service.
Yes, this category is closely related to necessary services, particularly things like training and education, but it has its own distinct focus.
And the rule is?
The rule is that a minor is generally bound by contracts of employment, apprenticeship, training, or even some forms of professional engagement, provided, and this is the crucial bit, the contract, when looked at as a whole, is beneficial to them.
Beneficial as a whole, not just bits of it.
Exactly. You can't cherry pick. You have to look at the entire agreement, the duties, the pay, the restrictions, the opportunities, everything, and weigh the pros and cons. If, on balance, the overall package is advantageous for the minor, helping them earn a living, get training, gain experience, or advance professionally, then the contract is likely binding.
Even if some clauses seem a bit harsh.
Potentially, yes. If those harsh clauses are outweighed by the overall benefits, like getting essential training or access to a profession, the contract might still be considered beneficial on the whole, but it's a balancing act.
Okay. The source gives case examples to illustrate this, right?
It does, and they're very helpful. Cases where contracts were found beneficial include Doyle v. White City Stadium, 1935.
Doyle v. White City Stadium, 1935. What was that about?
That involved a minor who was a professional boxer. He had a contract with the British Boxing Board of Control. Now, this contract had some restrictive terms, like he couldn't fight abroad without permission, rules about prize money distribution, that sort of thing.
Sounds potentially restrictive.
It was, but the court looked at the bigger picture. This contract, governed by the board's rules, was essentially his license to box professionally in the UK. Without it, he couldn't pursue his chosen career. So, despite the restrictions, the court found the contract was, on the whole, beneficial because it enabled him to earn his living as a boxer. Therefore, it was binding.
Makes sense. The overall opportunity was the main benefit. Another example.
Another one where the contract was upheld is Chaplin v. Leslie Fruin Publishers, 1966.
Chaplin v. Leslie Fruin, 1966. Any relation?
Yes, this involved Charlie Chaplin's son, who was 17 at the time. He made a contract with publishers for them to ghostwrite and publish his autobiography, which was expected to be quite scandalous.
Okay, and the contract terms?
They gave the publishers quite a lot of control and potentially tied up his story for a long time, but the court decided it was beneficial overall. Why? Because it provided him with a way to start a career as an author and potentially earn significant money from his name and story. The opportunity to launch himself professionally was seen as the key benefit, outweighing the less favorable clauses.
So in both Doyle and Chaplin, the courts looked at the practical reality of advancing the minor's career.
Precisely. But now, look at the crucial contrast provided by the source, the case of DeFrancesco v. Barnum, 1880.
DeFrancesco v. Barnum, 1880, this one went the other way.
Dramatically so. This involved a 14-year-old girl apprenticed for 7 years to learn stage dancing. The terms of the contract were, frankly, appalling. Well, she couldn't marry during the 7 years. She couldn't accept any professional engagements without the master's consent. Crucially, the master had no obligation at all to find her any work or maintain her during the apprenticeship. And the pay was incredibly low, something like 5/10 of performance, reduced if she was ill. Plus, the master could terminate the contract almost at will.
That sounds incredibly one-sided, almost like exploitation.
The court thought so too. They looked at the whole contract and said there was absolutely no way this was beneficial to the minor. The terms were far too harsh, restrictive, and offered her very little security or real training benefit in return. It was deemed oppressive.
So not beneficial on the whole.
Not even close. Therefore, the contract was not binding on her. DeFrancesco v. Barnum is the classic example of where an employment or apprenticeship contract crosses the line into being detrimental, and the beneficial as a whole test fails.
That really clarifies the beneficial as a whole test.
Yeah,
It has to be genuinely advantageous, not just exploitative under the guise of training.
exactly. It must provide real benefit.
Now, the source brings us right up to date with a very high-profile modern example involving a famous footballer.
Ah, yes, the Wayne Rooney case. Proform Sports Management Ltd v. Proactive Sports Management Ltd, 2006.
Proform v. Proactive 2006. So what happened here? Wayne Rooney signed a contract when he was a minor.
He did. At age 15, while he was already a promising youth player at Everton, he signed a player representation agreement with Proform Sports Management. This was essentially a contract for them to act as his agents, managing his image rights and negotiating commercial deals off the pitch.
Okay. And was this contract enforceable against him?
The court held that it was not enforceable against Rooney because he was a minor when he signed it. It was deemed voidable at his option.
Voidable. Why wasn't it seen as a beneficial contract of service, like helping his professional career?
This is the key reasoning. The court decided, first, it wasn't analogous to a contract for necessaries, but more relevant here, it was not considered a contract of apprenticeship, education, or service in the way the exception understands it.
Why not? It relates to his football career.
Because the contract wasn't providing him with training or employment as a footballer, he was already getting that from his club, Everton. This was a contract for agent services managing commercial opportunities off the pitch. Also, critically, at 15, he wasn't legally old enough to sign a professional football playing contract anyway. So this agency agreement couldn't immediately enable him to earn his living as a player or provide the actual training.
Ah, I see. It wasn't the core employment or training itself. It was an auxiliary commercial agreement.
Precisely. The court said it didn't fall within the established categories of apprenticeship, education, or service that need to be beneficial on the whole. It highlights the specific scope of this exception. It's really about contracts that directly enable the minor to earn a living or get trained for a trade or profession.
That's a really important distinction. The Rooney case shows the limits of the beneficial service exception.
It does. And the source makes another extremely important point in this section, a definite exclusion you must remember. Trading contracts are not included in this category of beneficial contracts of service.
So if a minor sets up a small business, buying and selling things.
Exactly. If a minor enters into contracts related to running a business, buying goods to resell, that sort of thing, those contracts generally won't be binding on them under the beneficial service exception, even if they hope the business will be profitable and beneficial in that sense.
Trading is treated differently. Why is that? Activity 7.3 in the source asks us to think about this.
Yes, it prompts that thought. The source doesn't give one definitive reason, but we can speculate on the policy. Trading is often seen as inherently more risky and speculative than, say, a regular job with a wage or a structured apprenticeship.
More potential for loss. Less supervision.
Quite possibly. Trading involves dealing with market fluctuations, managing stock, potential for debts if things go wrong. It often lacks the direct supervision or structured learning environment of employment. The law perhaps feels that exposing a minor to the full financial risks and liabilities of trading contracts goes against the core policy of protecting them from improvidence, even if the venture is intended to be beneficial.
So it's seen as a different kind of risk compared to learning a trade or profession through employment.
That seems to be the underlying rationale. Trading is out.
Okay, let's recap beneficial contracts of service. A minor is generally bound by contracts of employment, apprenticeship, training, or professional engagement. If the contract is beneficial to the minor as a whole, considering all terms. We saw cases like Doyle v. White City Stadium and Chaplin v. Leslie Fruin where they were beneficial compared to DeFrancesco v. Barnum where harsh terms made it detrimental. And critically, trading contracts are specifically excluded from this exception. The Proform v. Proactive Wayne Rooney case helps illustrate the limits the contract must be for the service training itself, not just related commercial activity.
Excellent summary again. You've covered the key aspects of beneficial contracts of service.
Right. Let's move on to section 7.3 in the source material. This covers a category described as a very mixed group known as voidable contracts.
Yes, this is the third main category we need to understand when dealing with minors' contracts. And the defining characteristic here is that these contracts aren't automatically binding like necessaries or beneficial service can be, nor are they necessarily completely void from the start. Instead, they are voidable.
Voidable. Okay, what does voidable actually mean in legal terms?
It means the contract does come into existence. It's considered valid and legally operative when it's made. However, one of the parties in our context, the minor, has a special legal power or right. They can choose to effectively cancel or set aside the contract, rendering it void.
So it exists, but the minor can kill it off.
That's a good way to put it. Until the minor exercises that right to avoid the contract, it remains perfectly valid and binding on the other party, the adult. The adult doesn't get to back out just because the minor could.
When can the minor exercise this right? When can they kill it off?
They have a window of opportunity. They can choose to avoid the contract either while they are still a minor, under 18, or, importantly, within a reasonable time after they reach the age of 18.
A reasonable time after turning 18, how long is that?
The law doesn't set a fixed period, like 6 months or a year. Reasonable time is a question of fact in each case. It depends on the circumstances, the nature of the contract, what's happened since they turned 18. But the point is, they don't have forever. They need to act relatively promptly after reaching majority if they want to repudiate.
What if they just do nothing?
If they do nothing for a significant period after turning 18, especially if they continue to take benefits under the contract, that might be interpreted as them affirming or accepting the contract, and they could lose the right to avoid it.
Okay. And the source mentions other ways the right to avoid can be lost. Something about third parties.
Yes, that's crucial. If, for instance, a minor acquires property under a voidable contract, like shares or land, and then perhaps after turning 18 but before formally repudiating, they sell that property to an innocent third party who pays for it in good faith.
The third party doesn't know about the original voidable contract.
Right. In that situation, the minor generally loses the right to get the property back from that innocent third party. The law protects the bona fide purchaser for value without notice. So third-party rights intervening can bar the minor's right to repudiate.
So the core idea of voidable is, it exists, it binds the adult, but the minor has a limited time window during minority or reasonably soon after 18 to actively get out of it, unless they affirm it or third-party rights get in the way.
That's it, exactly. It
Yeah.
exists until repudiated.
And the source really stresses the importance of distinguishing this voidable from a contract being void.
Absolutely fundamental, not just here, but across contract law. They sound similar, void and voidable, but legally they are worlds apart.
So what's the difference? Remind us what void means.
A void contract is, in the eyes of the law, a complete nullity from the very beginning. It's treated as if it never existed. It has no legal force or effect whatsoever. Neither party can enforce it, and generally, any property transferred under it should, in theory, be returned because there was never a legal basis for the transfer.
Like it never happened.
Precisely. The source notes that historically, the Old Infants Relief Act 1874 actually used the term absolutely void for certain minors' contracts, which caused a lot of confusion because, in practice, they didn't always operate like truly void agreements, leading to legal paradoxes.
Whereas a voidable contract
Does exist. It is a valid contract, legally effective from the start, until and unless the party with the right, the minor, takes positive steps to set it aside. This difference has huge implications, especially regarding things like transferring ownership of property or the rights of those third parties we just mentioned.
And the source mentions this void versus voidable distinction comes up again later in the course.
Yes, it flags that it's a key concept you'll encounter again, for example, when studying the topic of mistake in contract law. Understanding the difference is crucial for analyzing the validity and consequences of agreements generally.
Now, the source makes a really interesting, almost critical observation about these voidable contracts for minors. It questions the logic behind them.
It does. It makes you pause and think. It essentially asks, if the main goal of the law here is to protect the minor, why are these contracts only voidable? Why aren't they just treated as void from the start, like some other types of non-binding agreements?
Yeah, if you want maximum protection, wouldn't making them completely ineffective from day one be the simplest approach?
You'd think so. The source points out there's no single, entirely convincing theoretical explanation for why this specific group of contracts, often those involving acquiring property with ongoing obligations like leases or shares, ended up being classified as merely voidable.
So maybe it's just how the law developed historically.
That seems likely. It might be a product of judicial pragmatism over strict adherence to the protection principle. Perhaps making them voidable was seen as a compromise, giving the minor an out, but allowing the contract to function initially, which could be less disruptive for the other party and for things like property ownership compared to declaring it a complete nullity from the start.
So maybe a historical quirk or a practical compromise rather than pure logic.
It certainly leaves you with that impression. It suggests the law in this area isn't perfectly symmetrical or always driven by a single overriding principle. It's an interesting point for critical reflection.
Okay, so summary for voidable contracts. They exist and are valid initially, binding the adult. The minor can choose to set them aside, repudiate, either before turning 18 or within a reasonable time after. This right can be lost by affirmation or third-party rights. And crucially, voidable is fundamentally different from void, which means never existed.
Perfectly summarized.
All right, so we've looked at when a minor is bound, necessary is beneficial service, and when a contract exists, but they can get out of it, voidable. What about the other side of the coin, the adult or the business? If a contract isn't binding on the minor, or if the minor does avoid a voidable contract, what can the adult do? Can they get back property they handed over? That takes us to Section 7.4, recovery of property.
Exactly. This brings us right back to that central tension, protection versus fairness. And historically, the adult party was often left high and dry. Under the old common law, if you supplied goods or money to a minor under a contract that wasn't binding on them, i.e. not necessaries or beneficial service, getting anything back was very, very difficult.
So the minor could just keep the goods and not pay.
Often, yes. The remedies available to the adult were extremely limited. The Infants Relief Act, 1874, didn't really help matters either, and its confusing, absolutely void language arguably made recovery even more problematic in some situations.
So the law heavily favored the minor in terms of recovery.
Historically, yes. The protection policy often trumped the adult's desire to recover property. However, this is where that significant piece of legislation we mentioned earlier comes in again. The Minors Contracts Act, 1987.
Right, the 1987 Act. What did it change regarding recovery?
It made a big difference. It repealed those problematic old sections of the 1874 Act. And crucially, Section 3 of the 1987 Act introduced a new statutory remedy. It gives the court a power to order restitution in favor of the other contracting party.
Restitution, meaning?
Meaning the court can, if it considers it just and equitable to do so, require the minor to transfer back to the adult any property they acquired under the contract or property representing it.
So the adult can potentially get their property back now?
Potentially, yes. But it's not automatic. The key word is discretionary. The court has the power, but it doesn't have to order restitution. It will look at all the circumstances of the case. Was the minor fraudulent? Do they still have the property? Would it be fair to make them return it?
So it depends on the facts. Are there cases that guide this discretion?
The source mentions a couple of older cases, Stocks v. Wilson, 1913, and Leslie v. Schill, 1914. Now, these cases were decided before the 1987 Act under the old law and principles of equity.
Stocks v. Wilson, 1913, and Leslie v. Schill, 1914.
Right. They're still relevant because they illustrate the sorts of factors courts consider when thinking about forcing a minor to return property or money. They particularly focus on things like whether the minor obtained the property through fraud, like lying about their age, and very importantly, whether the minor still has the property or traceable proceeds from it. Equity was generally reluctant to make a minor pay back money if they'd already spent it, as that would be like enforcing a loan contract indirectly.
So the 1987 Act gives a statutory power, but the court will still look at fairness and whether the minor still has the goods, drawing on principles from cases like Stocks v. Wilson and Leslie v. Schill.
That's a good way to understand it. The 1987 Act provides the tool, but the court wields it based on principles of justice and equity, informed by that older case law, particularly around preventing unjust enrichment where possible without indirectly enforcing the non-binding contract.
This leads nicely into Activity 7.4 from the source. It asks, what's the position if a minor buys and pays for non-necessary goods, but then wants to cancel?
No.
Say a 17-year-old buys an expensive gaming PC, definitely not a necessary, pays cash, takes it home. Next day, regrets it. Can they demand their money back? And can the seller get the PC back?
Okay, good scenario. Let's break it down. Under the old common law rules, the contract for the non-necessary PC isn't binding on the minor. However, if the minor had already paid the money and received the goods, the general rule was tough luck for the minor trying to get the money back, because they couldn't usually recover money paid unless there had been what's called a total failure of consideration, meaning they got absolutely nothing in return for their payment. Since they got the PC, even if it wasn't a necessary, they couldn't just demand their cash back simply because they were a minor.
So money paid was usually on if they got the goods?
Under the old law, generally yes for non-necessaries. Conversely, if the minor hadn't paid, the seller couldn't sue for the price. It was often a case of let the loss lie where it falls once performance had occurred.
But what about the 1987 Act? Does Section 3 change things for the seller in this scenario if the miner tries to get their money back or just keeps the unpaid-for PC?
Yes. Section 3 provides a potential avenue, especially for the seller if the miner still has the goods. If the miner still possesses that gaming PC, the court could, using its discretion under Section 3, order the miner to return the PC to the seller.
To prevent the miner ending up with both the PC and potentially trying to recover the money.
Exactly. It aims to prevent that kind of unjust enrichment. The Act gives the court flexibility to achieve a fairer outcome than the sometimes rigid common law rules allowed, especially where the property is still identifiable and in the miner's hands. But remember, it's still discretionary. The court weighs the justice and equity. It doesn't automatically make the non-necessary contract binding. It provides a separate restitutionary remedy focused on the property itself.
Okay, so summarizing recovery of property. Generally, contracts outside the exceptions aren't binding on the miner. Historically, recovery for the adult was hard. But the Miners Contracts Act, 1987, Section 3, introduced the discretionary statutory remedy of restitution.
Right.
This allows a court, if just and equitable, to order the miner to return property acquired under the contract. Principles from older cases like Sox v. Wilson and Leslie v. Shale about fraud and possession still inform the exercise of this discretion.
A very solid summary of the recovery position.
Okay, that takes us through the core legal principles. Now, the really valuable part for anyone studying this, let's apply it. The source material gives us a great sample examination question, Linda's scenario. This forces us to pull all these threads together.
Yes, problem questions are the best way to test understanding. Let's look at Linda.
Okay, here's Linda's situation from the source. She's 16 years old, just left school. She's made 3 different agreements. First, she took a job as a trainee kitchen assistant at a hotel. Pay is £50 a week. Her contract says she has to give 3 months' notice to leave. That's contract 1.
Got it. Contract 1, hotel job.
Second, she agreed to buy an Osaka motorcycle for £2,000. She told the seller she was buying it so she could spend more time with her boyfriend, Malcolm. She hasn't paid the £2,000 yet. That's contract 2.
Okay. Contract 2, motorcycle for Malcolm, unpaid.
Third, she signed a written agreement to buy a 1/4 share in a racing greyhound named Dingo for £500. She hasn't paid this £500 either. That's contract 3.
Right, contract 3. Greyhound share. Unpaid.
Now, the twist. Linda has just been offered a much better job as a cook in a restaurant. It pays £100 a week, double her current wage, but they need her to start immediately. She wants advice on her legal position regarding those 3 contracts she's already signed up for.
Okay, classic scenario touching on multiple types of contract. Let's break it down contract by contract, applying the rules and cases we've discussed, following the source's own analysis. First up, contract 1, the trainee kitchen assistant job.
The 50-week job with 3 months' notice.
The key question here is this a beneficial contract of service? We apply the rule. Is it beneficial to Linda on the whole? We should think about cases like Roberts v. Gray, 1913.
Roberts v. Gray. Training, professional development.
Exactly. Linda's 16, just left school. This job gives her employment, a wage, even if modest, and crucially, training and experience in a specific trade kitchen work. Looking at the overall picture, the source's advice concludes that it's highly likely a court would find this contract to be beneficial employment for her.
Despite the 3-month notice period.
Yes, notice periods are standard in employment. Unless it was outrageously long or unfair in context, it probably wouldn't outweigh the benefit of the training and employment itself. So the conclusion, following the source's reasoning, is that this contract is likely binding on Linda.
Meaning, she probably has to give the 3 months' notice. Leaving immediately would be a breach.
That's the likely consequence, yes. She's probably bound by the terms of that beneficial contract of service.
Okay. Contract 1, likely binding. Now, contract 2, the Osaka motorcycle for £2,000.
Right, unpaid. The question here is this a contract for necessaries? We need to apply that Sale of Goods Act definition, suitable to her condition in life and her actual requirements at the time.
And think about cases like Nash v. Inman, 1908.
Nash v. Inman, definitely. Are fancy waistcoats, or in this case, a £2,000 motorcycle necessary? Let's analyze. Linda is a 16-year-old trainee earning only £50 a week. A £2,000 motorcycle seems like a huge expense relative to her condition in life.
Maybe she needs it for transport to work.
That's a possible argument for necessity, maybe, but the facts give us a crucial piece of information, her stated reason for buying it.
To spend more time with her boyfriend, Malcolm.
Exactly. That reason has absolutely nothing to do with her essential needs, her job, her training, or basic transport requirements. It points very strongly towards it being a purchase for pleasure or convenience, a luxury, not a necessity.
So the stated reason really undermines the necessity argument.
Hugely. Following the source's analysis, while a court makes the final call, the evidence weighs heavily against the motorcycle being a necessary. If it's not a necessary, the contract is generally not binding on Linda. Since she hasn't paid, the supplier cannot force her to pay the £2,000.
And if, hypothetically, it was found necessary.
Then she'd only be liable for a reasonable price, which might be less than £2,000 anyway. But given the facts, especially that reason, the strong likelihood is it's not a necessary and she's not bound to pay.
Okay. Contract 2. Likely not binding. What about Contract 3? The £500 share in the racing greyhound? Dingo.
Unpaid share in a greyhound. What type of contract does this look like? She's buying a share in an animal used for racing, presumably hoping for prize money or breeding value.
That's like an investment. Or maybe trading.
That's exactly how the source's analysis views it. It appears to be in the nature of a trade or a speculative venture. Now, what did we learn about trading contracts?
They are specifically excluded from the beneficial contracts of service exception.
Precisely. Even if Linda hoped owning a share in Dingo would be profitable and therefore beneficial in a general sense, it falls under the category of trading, which the law treats differently from employment or apprenticeship for minors.
So, because it's a trading contract.
It's unlikely to be enforceable against her. She's probably not legally bound by this agreement, and the seller of the share cannot force her to pay the £500.
Okay. Contract 3. Likely not enforceable because it's trading.
That's the analysis.
Right, let's pull that all together for Linda's advice based on the source's analysis. Contract 1, job. Likely binding as beneficial service, so she probably needs to give notice. Contract 2, motorcycle. Likely not binding as is probably not a necessary, especially given the reason. Contract 3, greyhound. Likely not enforceable as it's a trading contract.
That's the overall picture for Linda. And working through a scenario like that, step by step, identifying the contract type, applying the rule, citing the relevant case principle, Roberts v. Gray for service, Nash v. Inman for necessaries, the trading exclusion, that's exactly the process that solidifies understanding for exams.
Repeating those names and concepts really helps cement them.
It absolutely does. Practice with problem questions is key.
Okay, so to wrap up and really reinforce the main points, let's quickly run through some of the core questions highlighted at the end of the source material. These are like the key takeaways you should have from this deep dive.
Good idea. A final check.
First, what makes a contract of employment binding on a minor?
You should be thinking it's binding if, looked at on the whole, it's beneficial for the minor's training, livelihood, etc.
If a contract is binding because it's for necessaries, what price does the minor pay?
Not the contract price. A reasonable price.
How is necessary legally defined for goods?
Sale of Goods Act, Section 3.3. Suitable to the minor's condition in life, A&D, there are actual requirements at the time. Both parts needed.
Can you identify examples? Think context.
Yeah, like basic clothes might be necessary for one minor, but not another who already has plenty. Nash v. Inman. Or training might be necessary. Roberts v. Gray.
Can you clearly explain the two main exceptions? Necessaries and beneficial contracts of service.
Necessaries covers essential goods services based on status and need. Beneficial service covers employment training if advantageous overall, but crucially excludes trading.
What happens if a minor doesn't pay?
Bound for necessaries, reasonable price, and beneficial service. Generally not bound for others, but the supplier might seek restitution under the 1987 Act if property remains.
Does it matter if the contract is performed or unperformed? Executory.
Yes, historically it mattered more. But we saw with Roberts v. Gray that executory contracts for necessary services can be binding.
And finally, can the supplier get goods back?
Difficult under old common law for non-necessaries. But now, Section 3 of the Minors Contracts Act, 1987, gives the court a discretionary power to order restitution, return of property, if it's just and equitable. Think Stocks v. Wilson, Leslie v. Scheel principles.
Perfect. If you can confidently answer those, using the rules and cases we've discussed, you're in really good shape on this topic.
Absolutely. That covers the core ground.
So just to quickly recap this deep dive, we started with a general rule. Minors generally aren't bound by contracts. Protection is key.
But then the crucial exceptions.
Right. Contracts for necessaries, binding for a reasonable price, and beneficial contracts of service, binding if beneficial overall, but not trading.
Don't forget voidable contracts, too.
Yes, voidable contracts, they exist, but the miner can set them aside, different from void contracts.
And finally, the recovery aspect.
The potential for the other party to recover property, especially through that discretionary restitution remedy in the Miners Contracts Act, 1987.
It really comes down to understanding that balance the law tries to strike. Protecting the young person, yes, but also achieving some fairness in commercial dealings.
And realizing it's not always simple. Applying those tests, condition in life, actual requirements, beneficial on the whole, that requires careful thought about the specific facts.
Exactly. The nuances are key. It's not always black and white, which is what makes it interesting but also challenging. Understanding the structure and the policy helps navigate it.
And thinking back to that point the source raised about the voidable contracts category and why those contracts aren't just treated as void if protection is the main goal.
Yeah.
What does that lingering question suggest to you about how law develops? Is it always perfectly logical? Or is it sometimes about finding practical compromises, even if they seem a bit messy theoretically?
That's a great final thought. It does suggest law is often an evolution, a series of responses to specific problems, leading to rules that work practically, even if they don't form a perfectly coherent theoretical whole. It reflects that balancing act between principle and pragmatism, something definitely worth pondering further.
Indeed. Well, once again, our material for this deep dive was based on those excellent educational resources generously made available by the University of London, and they are intended solely for educational use.
Well, thanks to them.
And this deep dive was brought to you by Sinorbit Academy, Sri Lanka. To everyone listening who is studying this material, especially with exams on the horizon, keep reviewing, keep practicing with scenarios like Linda's. You are building that solid understanding. You've absolutely got this. Good luck for the exam.
Yes, all the best.
Thanks for joining us for this deep dive.